All may sit down. The court is now in session. This is the case of public prosecutor and Muthusamy. The accused has been convicted of robbery with the use of a weapon under section 392 and 397 under the Penal Code. The accused, Mr. Muthusamy, a 21 years old clerk, has pleaded guilty to the charge of robbing a convenience store in Kuala Lumpur on 12 November 2023. The facts indicate that the accused committed the robbery at knife point, resulting a minor injury to the cashier and theft of 1,200 ringgit, which has been recovered by law enforcement. Today's proceedings are focused on sentencing. I will hear the submission from both the defense and the prosecution to determine an appropriate sentences that balance the severity of the crime with the individual circumstances of the accused. Defense, you may now present your plea of mitigation.
Your Honor, I stand before the court today representing Muthusamy, a 21 years old young man who has already pleaded guilty to the charge of robbery with weapon. While I do not seek to diminish the gravity of his action, I humbly request the court careful consideration of the extraordinary circumstances that led my client to commit this regrettable offence. Muthusamy is not a hardened criminal but a desperate son facing an impossible family situation. He is the sole breadwinner for a family in critical need, caring for a disabled father who requires expensive treatment, and an employed mother and 3 younger siblings who depend entirely on his support. This conduct of criminal is crucial, Your Honor. Muthusamy's father suffers from a debilitating condition requiring urgent surgery and ongoing medication. The medical costs far exceed Muthusamy's modest as clerk salary. After exhausting all legitimate means of securing financial assistance, he found himself trapped in a desperate situation with seemingly no way out.
Your Honor, I would like to draw the court's attention to several mitigating factors. First, immediate guilty plea. My client has shown genuine remorse by immediately pleading guilty, demonstrating his acceptance of responsibility and saving the court's time and resources. Second, limited criminal history. Apart from a minor theft conviction 2 years ago, for which he was fined, Muthusamy has no significant criminal record. This suggests this offence is an aberration and not a pattern of criminal behaviour. Third, no serious harm. Your Honor, during the robbery, the injury to the cashier was accidental and minor, requiring only stitches with non-lasting physical damage. This indicates no intention to cause seriously bodily harm. Fourth, full recovery of stolen funds. The entire sum of 1,200 was recovered by the police, minimizing the financial impact on the victim. Fifth, family responsibilities. Your Honor, Muthusamy carries the entire burden of supporting his family, including caring for his paralyzed father and ensuring for his younger siblings and continue their education. Your Honor, while the law must be upheld, I submit that a sentence focused on rehabilitation rather than purely punitive measures would serve justice more effectively. My client is young, has demonstrated potential for reform, and is critical for his family's survival. The true punishment, Your Honor, has already begun. Muthusamy lives with the shame of his actions and the knowledge that he betrayed his own principles of honesty and hard work. In conclusion, I implore the court to see beyond this single moment of desperation and recognize the broader human context of this young man's actions. Thank you, Your Honor.
May it please Your Honor, I appeal for the prosecution in this case of Muthusamy, where the accused stands convicted of armed robbery under the section 392 and 397 of the Penal Code. Your Honor, the fact aggravated. On November 12, 2020, The accused deliberately entered a convenience store armed with a knife. He not only threatened the cashier, but the accused actually injury requiring medical attention. The sum of 1,200 ringgit was forcibly taken at knife point. Firstly, this was a premeditated offence involving a weapon. The accused made a conscious decision to arm himself before entering the premises. This is not the case of a spontaneous act, but one involving prior planning and deliberate use of violence. Secondly, Your Honour, the accused had a previous conviction for theft. While we acknowledge this for 2 years ago, it demonstrates that previous judicial leniency has failed to deter his criminal behaviour. We see a disturbing escalation from theft to armed violence. Thirdly, this offence strikes at the heart of public safety. Convenience store workers must be protected. They provide an essential service, often working alone and during vulnerable hours. A clear message must be sent that such act of violence will face severe consequences. While the prosecution acknowledged that the accused pled guilty in his difficult family circumstances, this cannot justify an armed robbery. Many people face financial hardship without resorting to violence. The accused chose not to explore legal options for financial assistance. Therefore, Your Honour, the prosecution submits that a sentence of 5 to 7 years imprisonment is appropriate to reflect the gravity of the offence and serve as both specific and general deterrence. Unless Your Honour has any questions, these are my submissions.
May it please the court, Your Honour, I appeal for the prosecution in this matter of Public Prosecutor versus Muthusamy regarding an armed robbery under Section 392/397 of the Penal Code. The prosecution acknowledged the complex circumstances of this case. The accused, a 21-year-old clerk, is the sole provider for his family, including his paralyzed father, who requires surgery. However, Your Honour, we must balance these personal circumstances against the serious nature of the offence committed. The facts reveal that on November 12, 2023, the accused entered a convenience store armed with a knife. He threatened the cashier and caused physical injury. He stole Rm1,200, thus this was later recovered. The victim required medical attention for their injuries. Your Honour, while we recognise his mitigating factors, the accused role as a family provider. Next, his father's medical condition. Third, his immediate guilty plea. And last, the recovery of the stolen money. We must emphasize that this offence has several aggravating elements. First, the premeditated use of a weapon. Next, the causing of actual bodily harm. Third, a previous conviction for theft. Lastly, the targeting of a vulnerable worker. The prosecution submits that despite the accused's personal circumstances, several factors necessitate a deterrent sentence. First, the protection of essential workers who serve our community during vulnerable hours. Next, the need to maintain public confidence in the safety of local business. Third, the importance of showing that violence cannot be justified by financial discretion. Lastly, the escalation from the accused's previous offence. Therefore, the prosecution recommends a sentence of 4 to 6 years imprisonment this balance. First, the serious nature of armed robbery. Second, the accused's personal circumstances. Third, the need for public protection. And lastly, the opportunity for rehabilitation. These are my submission, Your Honour, unless you have any questions.
This court has carefully considered the submissions presented by both the parties, which is the prosecution and defence, in the case of Public Prosecutor and Muthusamy, charged under Section 392 and 397 of the Penal Code for robbery with a weapon. The fact before us presents a complex scenario that demands a judicious balance between punitive measure and humanitarian consideration. The accused, a 21-year-old clerk, stand convicted of an armed robbery motivated by an extreme financial desperation.
We must first address the mitigating factors present by the mitigating defense. The court recognized Muthusamy's challenging family circumstances, a disabled father requiring expensive medical treatment, an employed mother, and 3 younger siblings dependent on his support. His immediate guilty plea and the minor nature of the physical injury are also noteworthy. However, these circumstances cannot and must not be viewed as a blanket justification for criminal conduct.
The prosecution has rightly pointed out several critical considerations. The accused has a prior conviction for theft, indicating a pattern of choosing illegal solution to financial challenge. More importantly, the use of a weapon during the robbery represents a serious escalation of criminal behavior regardless of the intent. Section 392 of the Penal Code provides for a potential imprisonment of up to 10 years with the possibility of whipping. The court must consider both punishment and rehabilitation.
After extensive deliberation, this court finds that a balanced approach is necessary. We cannot ignore the societal imperative of protecting public safety while simultaneously recognizing the human element of the accused circumstances. Therefore, the court hereby sentences Muthusamy as follows. The first one is a substantive prison term of 3 years, reduced from a potential maximum sentence in recognition of his earlier guilty plea and family circumstances. The second one is mandatory attendance in financial counseling and vocational training programs during and after imprisonment to provide sustainable alternative to criminal activities. The third one is a requirement to pay compensation of Rm 1,200 ringgit to the convenience store representing the amount stolen. And the last one is a post-release probation for 2 years during which the accused must maintain regular employment, submit periodic reports to a probation officer, seek additional support for his family through legal and social welfare channels.
The court hopes these sentences achieve multiple objectives. It punish the criminal act, protect public safety, provide deterrence, and crucially, offers the accused an opportunity for rehabilitation and positive redirection. Let this message serve as a clear message. While this court acknowledges individual hardship, the law must be upheld. There are always legal alternatives to criminal action. Case closed.